I've been dealing with immigration appeals for over 20 years now. And in case you haven't noticed from the videos already, I absolutely love what I do. Today I'm in Birmingham and just finished a court hearing where we had a very lengthy legal argument, which usually does not happen because today was one of those exceptional kind of situations where the judge, the Home Office presenting officer, and myself as the appellant's representative got together into a proper legal argument where we threw things back and forth rather than simply making submissions. Those of you who have been in appeals before would know that what happens usually in an appeal is that once the evidence stage is over, when everybody has given their evidence and have been cross-examined and have been re-examined, after that, the judge invites the representatives to do their submissions. So the first part is where the Home Office presenting officer will go with their submissions, say all the reasons, say all the things that they wish to say in support of the respondent's position, which is that the appellant's case should not succeed. Then, of course, the appellant's representatives, which is yours truly, will be given the opportunity to make their submissions. Now, today was a case where there were two main points. This gentleman, who was in the UK since 2011, has been an overstay, got into a relationship, a genuine and subsisting relationship with a British national, and was arguing that he should be allowed to stay here on that basis. The Home Office position was, no, we're not even going to consider your relationship because back in October 2012, you submitted a TOEIC test certificate, which was found out later to be invalid, which means that you had knowingly submitted a fraudulent document for an immigration application within the UK for leave to remain. Now, the Home Office position was TOEIC, nothing to look into, and that's it. He has been found to be deceptive, and because of that, we will now say that he does not meet the suitability requirements. Now, when it was time for my submissions, I had been building up this point throughout the submissions of the presenting officer. My question, the first question I asked as soon as he finished, I said, before I start my submissions, I would just like to have clarification from the respondent on one point. And that one point simply is, if a person is found to have been deceptive in the TOEIC test, let's say we accept that this guy made a mistake or deliberately submitted a fraudulent TOEIC test certificate in his application for leave to remain in 2012, which becomes an immigration offense. Now, if we accept that, how long is he going to be punished for? How long does that stay in the rules, or does that stay as a slur or a problem for him? Because if October 2012 was when he had done this, this is 12 years on. October 2024 is going to be 12 years. So it's almost 12 years since the offending act. And if the offending act is submission of a TOEIC certificate at the time of your leave to remain application at that time, then are we going to start counting the time from there? And if we are counting the time, what is the time? That was the question. And the judge was like, that is an interesting question, Mr. Bukhari, and was put to the Home Office representative, who was equally bemused and said, well, I don't know. And fortunately, I have somebody very senior from the Home Office in the building, so I'm going to make some inquiries. And the judge, after a few more minutes of discussing with me, also decided that she was going to go and consult another judge. So it became a very interesting afternoon where we are going through the rules, we are talking to different judges or Home Office representatives, and nobody could come up with what the time frame was that this is going to stand against him. My argument was 9.8.7 of the immigration rules. When you look at the grounds of refusal and then you look at 9.8.7, it says very clearly that if there is a re-entry ban that we are going with, what is that re-entry ban and how long will it be effective and where does it start? So when you go into 9.8, you go through all those points. There's categories A to F. And right at the top, it says that if you're looking at the time frame, these are re-entry bans, basically. So what it says is that you will be banned for 12 months if you returned voluntarily after overstaying or after an immigration offense, or you'll be banned for 5 years if you took help and left, if you were arrested and detained by the Home Office or the authorities, and then you were removed at public expense, then you will have a ban of 10 years. Now, all that is fine, except category F, where it says where you have used deception in an application. And then it goes on to say, for visit visa applications, this would be for entry clearance only. So the Home Office presenting officer was arguing that this only applies once the 10 years start after you've left the UK. So according to the Home Office presenting officer, what he was saying was that the offending act was in 2012, October 2012, and from there till now, none of this time is going to be counted, and only from the time when he leaves the country will the 10-year ban start. To which it became a very interesting argument, because I said to the judge, let's say we are assuming that this guy did not commit fraud with the TOEIC exam, but he committed theft. He had a criminal offense against him. So if he had a criminal offense and he was not imprisoned for more than 12 months, then there will not be a deportation order against him, which means that after a short while, 5 years or 10 years from the date of offense, he will be able to come back. So producing a TOEIC exam or a TOEIC certificate is worse than committing a criminal offense and going to prison. How does that make sense? Does that come under the suitability requirements? Does that come under the proportionality, the assessment that needs to be carried out? So I know I'm talking a few technical points here, but I think all those people who have been involved with TOEIC exams will find this very interesting, because today, when I was talking with the judge and we were arguing the matter, by the end of it, we agreed to a point which I thought I will share in a video. And that is of relevance to every person who was involved in a TOEIC exam. The way the rules are drafted and the way at least I've argued it today, and I am very confident that the Home Office have absolutely no leg to stand on with this. And the judge was with me, by the way, because at the end, when I got up and left, the judge said, Mr. Bukhari, very interesting legal arguments. And I'm glad that we looked into this area and we clarified something. So I'm sure the judge is with me on this. So the point was, and this is the crux of it all, the point is, if you committed a fraudulent act or a deceptive act of submitting your TOEIC certificate, let's say this was 2012 or 2013, from there, from the date of decision when your application was refused because of that, that is where your 10 years will start. Because right now, when we go into courts with these TOEIC cases, usually the Home Office does not give you a time. Because my other question was that if suitability is a problem, and you're saying that this is not conducive to public good, that this man should be allowed to stay in the UK, then that means if he goes back to Pakistan, he was from Pakistan, by the way, if he goes back to Pakistan, he cannot succeed on the entry clearance application either. Because that would mean that if you're saying that it is not conducive to public good, and then we say that suitability requirements are not met, then even if he were to go back and apply for entry clearance to join his wife, who's a British national, he will not be able to do so if this is the way the law is. So we had to come up with a time frame. And when we looked at 9.8.7F, that is where we come in and say it is 10 years from the date of decision. So this person made an application in 2012. He was granted status till, I believe it was somewhere in 2014, February 2014. And then he submitted another extension application. And that application was refused because they said you submitted a fraudulent TOEIC exam test in the previous application. And that date of decision was somewhere in May 2024. Now, from the date of decision, if we look at it, then today we have already passed 10 years. 2014 to 2024, which means that now he could be considered under the rules. But that would be if the application was now being made. So a previous application in this particular matter, he had made the application in 2021. So therefore, 10 years had not yet passed. But today, looking at this now, 10 years have now passed. So if you or somebody else in this situation who had taken a TOEIC exam, had been refused continuously over the last 10 years because of deception, now you can make a new application and that cannot be used against you. So I hope this would be very helpful, and anybody who has been involved in the TOEIC saga will remember and recognize how many different stages there have been with these TOEIC exams and these TOEIC tests. There have been cases where we have been able to win the cases on the APBG report of the Parliamentary Commission. Then there have been other case law which we have used many times. Now there is DK and RK, which says You have to look at all the circumstances. The Home Office bundle is enough, and then it goes on to the proportionality again. Thank you very much for listening. Hopefully this will be of use to any of those people who have been involved with the TOEIC exams, and hopefully now we can do a much better application for you.